Is this the unanimous verdict of all? If you will, signify by raising your right hand. Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention. All right, we have set a sentencing hearing on Mr. Vaughn's other charges on January the 28th, so this case will also be combined for sentencing on that charge as well. Then we'll let you know as soon as possible, Mr. Vaughn, whether we're going to be trying some more. We can expect to try at least one of those cases, the driving on revoked license, on the 23rd or 24th, depending on one of those 2 days. Just expect you're going to go forward on your driving on revoked license that I allowed you to withdraw your plea on. It's been filed. My understanding is that this morning prior to our breaking for lunch that you had some issue that arose where you had some issue with me or something about the way I was conducting court. Is there anything you want to address on the record?
Are you going to send me downstairs like I'm the one making the noise or not? You don't know who was back there talking? I wasn't the only one talking.
The only thing that I know is that there was noise being committed. But the first and foremost thing is the motion to withdraw your guilty plea. In the case that we tried last week, you had pled guilty to the driving on revoked license. So if you want to address that issue, then I'm going to let you take up each one of your motions. I have a motion to withdraw your guilty plea, a motion to continue the sentencing, a motion for a transcript and all judgment papers, and a motion to compel evidence, including copies of YouTube videos. So we're going to take those up in that order. So if you'll come to the podium, I will hear what you have to say on each one of those motions.
All right. What was the first one again?
First one is your motion to withdraw your guilty plea. At the trial, you were charged with driving on a revoked license, third offense. You entered a plea of guilty to count 1. That waived your right to contest the issue of whether you're guilty or not guilty of that. Obviously, there's not been a sentencing hearing on that, so you would still have the right to appeal whatever sentence I imposed in that case, but you would have waived your right to contest your guilt or innocence of driving on a revoked license.
I object. The rule states that you can place a withdrawal of guilty plea before sentencing, and we haven't even been to sentencing yet. So that I'm well in the rights to withdraw my plea to guilt. I was under the pressure of my assistant counsel, and I feel like
that you're requesting a continuance in the sentencing, that you want time to prepare some preservable rights for appeal, and that the delay is only requested to receive the transcript from the trial. I understand. Is there anything you want to add to what you've written there?
Yeah, basically a question for a continuance, because I plan to put in a motion for a new trial, and without the facts of the dates and the circumstances, what he said and she said, I mean, I couldn't give you a good, well drawn up motion for new trial to properly preserve for appeal.
All right, then we'll move to the third motion, which is a motion for a transcript and all of judgment papers. And if I understand correctly, you're stating that motion to request transcript and all judgments and papers filed into the case to date by compellment. I'm assuming you mean, I don't know what you mean by compellment, but you want to request a transcript of the trial, is that correct?
Yes, I want a transcript of the trial, and I want any and all papers filed in by myself and the public defender and my paid attorney. This is not the first time I've put this into the courts. It goes along with filing for new trial. There's due process errors and other errors.
Vaughn is using legal adjacent language here, like compellment, which isn't a standard term. This is a classic hallmark of pro se defendants who have spent time in the law library but lack the practical experience to apply the terminology correctly.
Errors that the record can show, and it's in the possession of the courts.
I will hand you a copy, Madam Clerk, if you will raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God. I am holding in my hand a copy of the transcript of the record in his case, and I'm asking you, is this a true and correct copy of all of the pleadings, all of the documents contained within his file, in all files? So this would constitute a complete transcript and copies of all documents. Deputy, if you'll just put that on the table, I'm delivering those, let the record reflect that Mr. Vaughn is being given a copy of the entirety of his file. The last motion you have is a motion to compel evidence, and you state that you want copies of all YouTube videos to be made available on USB or playable DVD or CD from the date of your arraignment to date. Those videos are relevance to your appeal. Anything you want to add to that?
It stands for the same reasons that for all papers, to Your Honor, the same exact reason.
Okay. If that's all you have to, if there's anything else you want to add to those motions, that's what we're hearing today. I'm sorry.
Is that all from arraignment date? I do have a request of the courts, though. I still have some video evidence at the jail. And
Video evidence of what?
Of the discovery that was in my discovery packet at the jail. And they're under the impression that I don't have any more court. When I asked to view it, they're telling me no.
Well, they'll be notified that you've got trials coming up. The trial tomorrow is a failure to appear, which shouldn't have any video evidence that would.
No, that's understandable, Your Honor. I don't understand where they're getting their information that I'm through with courts, and it's hindering me to be prepared when I come to court.
But we'll make sure that the bailiffs relay to the jail and that the clerk relays to the jail. You do have other cases pending.
Are we going to make a ruling on the rest of the motions today, Your Honor?
I'm going to make a ruling on your motions today after we hear from the state.
Okay.
Judge, on the motion to withdraw guilty plea, I searched for case law that was on point where a plea was entered in front of the jury, and there's not a lot out there. I did not find a single case with those specific facts. I did find, and of course it is my duty to tell the court any case law that I find that is against my interest. There is substantial case law that talks about how the defendant must be notified of all his rights in a waiver and waive them knowingly and voluntarily and say that on the record. I don't think we did a rights waiver in this case, and so I leave it to the court's discretion if that would be reason for the withdrawal of the guilty plea. Based on how you rule on that, with the sentencing, normally the defendant would not need to file a motion for new trial until after the sentencing. So I don't know that he needs transcripts before.
That the advice given to him by his elbow counsel was, in fact, not the appropriate advice, or it was not sufficient because he did not realize that he could not appeal a guilty plea. Well, he can appeal the sentence imposed, but he cannot appeal the finding that he's guilty of driving on a revoked license. But because of the fact that essentially Mr. Vaughn is arguing that he was not fully aware of his rights, and because this is the state pointed out, normally this is done prior to trial with what we call the Mackey rights, where I explain all of the rights and go through that litany of rights that they have prior to accepting the plea. The only other option would have been to have suspended the reading of that indictment to the jury and his response, send the jury out of the room, and then conduct that. And probably that would have been the better practice. So I'm going to grant his motion to withdraw his guilty plea as to that driving on revoke.
This is a massive win for Vaughn that you rarely see. The judge admitted a procedural slip-up regarding Mackey rights, basically the set of warnings given to ensure a plea is voluntary. By granting this, the judge is protecting the court from a guaranteed reversal later.
Charge, and we'll place that back on the docket in a separate, it'll be tried separately than anything else. So essentially, you're going to have a separate trial on that charge. The motion to continue your sentencing, I'll grant that as well so that you have time to be able to do whatever. Then the next motion is for a motion for a transcript and all judgment papers, which I have supplied to you. And then the last motion is a motion to compel evidence, which is arguing that you should be entitled to a download of all YouTube videos. This court finds that those YouTube videos are in the public domain. They are not evidence that was utilized in the trial of your case. And for that reason, this court does not find that there is any obligation on the court or the state to download and go back through and every hearing that you've had. You have a right to transcripts of hearings if it gets to show what happened in court. The Court of Appeals does not consider a YouTube video. They don't watch videos when they consider an appeal. They refer to the written transcript and the exhibits. So your motion as to the YouTube videos being compelled to be brought before you, I am denying that motion. That concludes all of the motions that were set before the court. The jury back. I want to deal with this. Mr. Vaughn has filed a motion to dismiss. The motion states as follows: I, Sherrick Vaughn, affirm that the foregoing is true in the best of my knowledge under the penalty of perjury. I move the courts to dismiss for staleness of the prosecution, maliciousness, and lack of notice. Neither witness or trial was given notice more than 18 hours. This is clear prejudice against the defendant and a threat to justice. My pray to the courts is for dismissal of this court for lack of due diligence, failure to follow notice rule of Tennessee criminal procedure. All right. This is one of the pending cases that has been pending for some time. It is certainly not a new case that's been suddenly brought. It is a case that was one of 4 cases, Mr. Vaughn, you did or did not fail to appear, and whether or not there was any justifiable reason for it. And as a result of that, this court granted your motion for a speedy trial and set it for today. And at that point, yesterday, you voiced no opposition to it. And I asked you if you wanted to represent yourself and said, of course. So we are here today only because of the fact that you had requested a speedy trial. We're giving you a speedy trial on this issue. We'll work on the speedy trial for the remaining cases that you have. And but your motion to dismiss is respectfully denied, and we are ready to bring the jury in. All right, we're going to read you the initial charge. Ladies and gentlemen of the jury, the defendant is charged in the indictment with failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt that the defendant had been directed to appear by a lawful authority, having been released from custody with or without bail on condition of subsequent appearance at an official proceeding. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing.
Call Pam Lewis. Are you Pam Lewis?
Yes, ma'am.
And you are our Dixon County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your
We've moved into the actual trial for the failure to appear charge. The state is starting with the court clerk because, in these cases, the victim is the court system itself. The clerk is there to prove the defendant was legally ordered to be there and didn't show.
staff are present for all circuit court dates.
Yes.
And in this case, we are here. Sharik Marquis Vaughn is on trial, and we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dixon County.
Yes, it was before Judge Lockard Mash.
And he needed to appear in the same courtroom that on July 19th as he was on July 24th.
Yes, ma'am.
And was his court date announced on that July 19th date?
Yes.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Good morning.
Morning.
I believe you just stated to Miss Bryson that your job title is to maintain court records.
Yes, sir.
Okay, what type of records are they? Like,
We have criminal records, civil records.
are you biased against me?
No,
You are not.
no.
Okay. Do you recall speaking to? Are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
I don't have it with me saying that.
No, sir.
Okay, it says that the copy I have that you spoke to Lee Spratt, and Lee Spratt spoke to you and said he had no contact with me.
That was the day of the trial. He announced he had no contact with you.
Okay. Is Lee Spratt my elbow counsel?
He was, yes, sir.
He was my elbow counsel.
Yes, sir.
So he can make statements on my behalf and testify on my behalf.
Yes.
He can without my lead.
No, not without your permission.
Okay, so he did that free will.
I guess so.
Okay. You said that you keep a record of everything filed into this court. Have I ever filed a complaint against you?
No, sir.
Have I filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that I want to say last year, and I was released upon out of this court.
Let me think. On July 19th, the day you was here, that Judge Lockren Mash.
May she resume her duties if she wants to? You want her at the table with you. Go back to the table and have a seat.
The state's case only took a few minutes. That's because failure to appear is a documentary crime. If the paperwork says you were notified and the clerk says the chair was empty, there isn't much more for the prosecutor to prove.
State may call your next witness.
Judge, that will be the state's case in chief.
State has rested their proof, Mr. Vaughn. Ladies and gentlemen, if you'll step across the hallway for a moment, let me take up one matter. Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right. Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events and so forth. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Yes, sir.
All right, then have a seat. Bring the jury back. All right, ladies and gentlemen, the state has now rested. Mr. Vaughn, you as the defense have the right to present proof. Do you wish to put on any proof?
No, sir.
All right, then the state has rested, the defense has rested. So you will now hear if there's any closing arguments that the sides wish to make, and you will hear from them.
Lady would have known of his court date and that just a few days later, he failed to appear for that court date. And as such, the state will ask you, you're going to receive instructions from the judge and a jury verdict. You'll go back and elect a foreman, and the state will ask you to return a guilty verdict for failure to appear. Thank you.
Mr. Vaughn, you have the right to address the jury, but you may not testify. You may only argue about the facts.
You just heard me ask the witness multiple questions about whether she was biased and whether I filed a complaint against her. She testified that I have. You've also heard that I've been charged with failure to appear out of this court before too, and it was also dismissed. You've also heard that I've asked the witness whether there has been errors made before in my case, and you also heard her state yes. I'm asking y'all to take this and do the best y'all can. Thank y'all.
State has the final say if you wish.
Judge, I'll waive.
All right, then, ladies and gentlemen, we have a final set of instructions to give to. All right, ladies and gentlemen, this will be the final charge of the court. The defendant, Sheriff Marky Vaughn, is charged in the indictment with the crime of failure to appear. You may now retire to begin your deliberations. Ladies and gentlemen, if you will step across the hallway, you may begin your deliberation. All right, Mr. Vaughn, if you'll step back with the officers, we'll bring you out when the jury is.
I have a quick question, if I could, Your Honor. This is about yesterday, if I can just gain some clarity.
Go ahead.
I haven't had.
As far as if you're asking for a transcript of every time you appeared in court, that will be a lengthy procedure to have to identify what days we're talking about. Then the court reporter would have to have a sufficient length of time to type everything up, which will be a very difficult thing for her to do on a short-term situation. So, all right, so there's an order granting you a transcript, but you don't have it yet.
All right, thank you, Your Honor.
All right. Jury has reached a verdict, so we're going to bring in Mr. Vaughn and we'll find out what the verdict is. All right, ladies and gentlemen, I'm told that you have reached a verdict. Is that correct? Will the foreman please stand and announce as to the indictment, the charge of failure to appear, how does the jury find the defendant? Guilty or not guilty? All right. Is this the unanimous verdict of all, if you will, signify by raising your right hand?
That was an incredibly fast deliberation. When a jury returns that quickly, it usually means the evidence was overwhelming. For Vaughn, the technical win he got earlier on his driving plea is now overshadowed by this new felony conviction.
Show that all jurors have signified that this is a unanimous verdict. Thank you, ladies and gentlemen. We're going to dismiss you now, but thank you for your time and attention. All right, we have set a sentencing hearing on Mr. Vaughn's other charges on January the 28th, so this case will also be combined for sentencing on that charge as well. Then we'll let you know as soon as possible, Mr. Vaughn, whether we're going to be trying some more. We can expect to try at least one of those cases, the driving on revoked license, on the 23rd or 24th, depending on one of those 2 days. Just expect you're going to go forward on your driving on revoked license that allowed you to withdraw your plea on.
Sharik Markey Vaughn was sentenced to 24 months in state prison, followed by 36 months of supervised probation.